I will be talking about a different approach to copyright. I guess we could call it a commons-based approach or a peer-to-peer production approach to copyright. Mainstream copyright regimes, as Thorsten has discussed, can be described as geared towards making the right exclusive, protecting your right to the copies of the content. If you want to reuse or build up on previous content, the only sure way to do it and avoid copyright problems later on is to have your lawyer talk to the original creator's lawyer and make sure that there are no copyright issues. This system works fine in the centralized mode of producing and distributing content, as copyright will be managed by the people controlling the production and distribution channels, the middleman, music companies, media companies, and publishers. Now, what if I want to share content I produce? I want to collaborate with other people around the world in producing content. This is what is known as peer-to-peer production. I want to collaborate with my peers. Also, what if I want to share the content I produce to schools and other non-profit institutions? This is where the GNU GPL, General Public License, and Creative Commons License comes in. GPL is generally used in the software world, while Creative Commons is used for text, image, music, and other cultural artifacts. With GPL, the author or the creator of the software retains the copyright and distributes the software with a GPL license attached to it. Now with GPL, anyone can get a copy, modify the software, and redistribute the software, on the condition that if you want to redistribute the software, you must redistribute it with the modifications you make with the same GPL license attached to it. As such, it has been cheekily referred to as copyleft instead of copyright. GPL enables persons down the track to benefit from the original rights extended by the original author of the software, as well as incremental improvements on the software itself. Creative Commons, like GPL, is also a license. With Creative Commons, the creator of the content extends a spectrum of rights to further users of the content. Creative Commons is really geared towards a digital environment because the license granted is human readable. It means you don't really need a lawyer to understand what type of license is being granted. It is also computer readable so that you can have your computer, your browser, search for Creative Commons licensed content in the web. With Creative Commons, the rights granted are marked by 5 cute icons explaining which or indicating which right is being extended. Briefly, the 5 rights being extended are 1. Attributable, which means you can distribute the content as long as you give me credit by including my name and a link to the license I am extending together with the content you are reusing. Second is non-commercial. It means you can reuse the content for non-commercial purposes. If you want to profit from my work, you have to ask my permission first. Third, non-derivative. It means you can reuse or redistribute the content as long as you don't modify it, you keep it intact. Fourth, share alike. It means you can redistribute the content provided you redistribute it with the same licenses as I gave you. So this one is quite similar to the GPL license. Lastly, you have public domain. With public domain, it's in the public domain. You can do whatever you want with the content. So the question to ask is, has GPL and Creative Commons worked in the real world out there? And I would say yes. A clear example would be the Linux operating system, which is under an open source GPL license, and this operating system and other similar software are now being used by Amazon, CNN, Google, and other big companies to run their websites. With Creative Commons, we have the Wikipedia as an example. It's an online encyclopedia, totally run and contributed to by volunteers, and the quality of Wikipedia is said to be comparable to the quality of Britannica, which is the standard for encyclopedias. You see, there are other ways of earning or profiting from your intellectual property or from your content. For example, in the case of Linux, the programmers who contribute to Linux earn money not through the license from each software copy, but through support, training, and setting up of the actual systems. And with Creative Commons, it's a way for people to gain reputation out there in the marketplace. And once you have that reputation, you can earn money from consulting fees. Similar to the way lawyers work, we don't really sell the advice we give, but we sell our expertise as a person. They pay for our time, not for each single letter or each single article we publish out there. Finally, let me say that IBM, the big computer company, which is one of the biggest holders of software and other patents, is also one of the biggest supporters of Linux and open source software. In fact, I think recently they have earned around $2 billion in revenues in Linux and open source related initiatives. Now that's something to think about, in the sense that this Creative Commons, GPL, and other modes of copyright is not really meant to eradicate the existing regime, but can coexist side by side to it, in the same manner that we had common law coexisting with equity, two rivers whose waters never mingle. It can be the same. Some people might want to choose the traditional copyright regime. Other people might want to choose the alternative copyright regime. Now it's up to people to discuss what they would prefer.